So we said there are two theories of sexual harassment. We started with quid pro quo, the this for that. The other theory, the one that you're most likely to see on TV or in the news or on the web, is what we call hostile work environment sexual harassment. Now again, to establish hostile work environment sexual harassment, we start with the prima facie case. And the prima facie case for hostile work environment means that the plaintiff must establish 4 elements. First of all, that he or she suffered discrimination because of his or her sex. Remember that sexual harassment, like every other aspect of Title VII, is bidirectional. It applies to men and it applies to women. So that's the first thing you have to show, that you suffered some sort of discrimination because of your sex, because of your membership in a protected class. You must show that the discrimination was pervasive and severe. Pervasive and severe, we'll talk more about the meaning of those words subsequently to this. But in essence, that's the second step you have to establish. That the discrimination was pervasive and that it was severe. Severe enough that it presented you with different terms and conditions of employment than another party in the office. You have to show that the discrimination detrimentally affected him or her. Meaning there must be some damage. Now, historically we looked at economic injury, that there was some sort of economic injury suffered. But in the very first sexual harassment case that went to the Supreme Court said the detriment can be other than economic injury. It can be things having to do with mental anguish and concern and medical issues in which you develop anxiety or something along those lines. So you have to show that the conduct, the hostile work environment, detrimentally affected you. And you have to show that not only were you detrimentally affected by the conduct, but that it would affect a reasonable person of the same sex. And again, we'll talk about where this perspective came from. But in essence, there are 2 aspects to the prima facie case. There is the subjective aspect, which is to say, I was harmed by it, I suffered because of the sexual harassment. But then there's also the objective component, which is to say, anybody in my position would have suffered the same detrimental effect. So those are the standards for the prima facie case of hostile work environment. Again, this came out of the first case to reach the Supreme Court having to do with hostile work environment. And in this case, it involved a bank employee who had been terminated from her job. She brought a lawsuit that says she had suffered from sexual harassment by her supervisor for 4 years prior to the termination of her position. And the court had to address, well, if she did not suffer an economic injury, if she didn't suffer a tangible job action, a loss of pay or a loss of hours, if that was not related to her claim, then in fact, was it actionable sexual harassment? And in this case, the court said yes, and then established those 4 elements of the prima facie case that had to be met. Now, employers are often confused about what conduct rises to the level of hostile work environment, and unfortunately it's a very gray area. We know from court cases that a finding of hostile work environment requires more than occasional comments or references. There has to be more than occasional offensive conduct. Even if the conduct is offensive, it will not create a hostile work environment unless the conduct is severe and pervasive. So occasional comments are going to be legal under Title VII standards. Even offensive conduct may be permissible if it was not severe and pervasive enough to create a hostile work environment. Now, there are certain types of conduct that we know will create a hostile work environment, and there's a litany of cases explaining those types of conduct, oftentimes having to do with offensive jokes or emails that are spread around the office, the posting of nude photos of either sex. That type of conduct almost always will create a hostile work environment. Now, the plaintiff, again, must show unwelcome activity. The basis of hostile environment sexual harassment actions is unwanted activity. And if the activity is wanted or welcomed by the complainant, there is no sexual harassment. So again, this threshold issue, you have to show that the behavior was unwelcome. And this can be difficult because oftentimes you're in an office, you want to get along, you want to go along, you're going to laugh at the jokes, you're going to smile when someone makes offensive remarks. Unless you can establish that that behavior was unwelcome, it's going to be very difficult to prove your sexual harassment claim. So how do we establish that? Well, we can look at direct actions. You know, obviously, if you make a complaint, that's going to establish unwelcome activity. If you notify your supervisor, that's going to establish unwelcome activity. We can also look at indirect actions, things that are outside of the workplace. If you tell your family or your friends about the activity, if you seek out a therapist to assist you with the trauma produced by your work, then that's another evidence of unwelcome activity. It could even be things like increased absenteeism or changing our request to be transferred from one office to another. So courts can examine both direct actions and indirect actions to determine the welcomeness of the activity. Now, the standard of hostile work environment is not always clear. This case was another one of those mid-1980s cases in which the standards of sexual harassment were evolving. And in this case, it concerned a situation in which an oil field services company had hired its first women, and the women came to the workplace, and at this time, back in the 1980s, it was routine for dirty jokes to be told. There were pinups taped up on the walls. There was rough language. And it had always been this sort of activity at the company. The women are hired and brought into the workplace, and they find the conduct offensive, that they find it that it is producing terms or conditions of employment that are different for them than for the men in the workplace. Now, this case goes to the Sixth Circuit, and the Court of Appeal sides with the oil company, the refining company, saying that there was a pattern of behavior that had been perfectly legal for years beforehand, and the introduction of women in the workplace did not suddenly make that behavior illegal. So that was the question is, can we criminalize or not criminalize, but make civil liability apply where there was no civil liability before this? All that's changed is the sex of the workers in the workplace. Now, there's a dissent filed in the Rabideau case, and the dissent in the law, whenever one of the justices on an appellate court disagrees with the majority opinion, the justice can write what's called a dissent. And then the dissent in Rabideau became famous by essentially establishing that sometimes things change, cultures change, societies change, and therefore the law must change with it, that the law should reflect societal beliefs. And if at this point in time society finds that offensive conduct or passing around of jokes or posting of nude photos, if society finds that offensive, then maybe the law needs to reflect that characterization. Now, he said that an abusive work environment requires severe and pervasive intimidation, ridicule, insult, and oftentimes courts are faced with the question of whether the harassing activity was severe and pervasive enough. Now, when we talk about frequency and severity, these often work in an inverse relationship. So the more frequently the behavior occurs, then the less severe it has to be in order to constitute hostile work environment. Similarly, the more severe the behavior, the less frequently it has to occur in order to establish a hostile work environment. So when we think of severe and pervasive, think about things like the frequency of the conduct and how bad the conduct was. And again, they work in oftentimes inverse order, meaning the higher the worse the severity was, then the fewer times it had to have happened in order to constitute sexual harassment. In this case, Ross v. Double Diamond, this involved a real estate developer, a realtor's office who hired a new receptionist to come work. It was an all-male office. The woman comes to work on her first day and is immediately subjected to horrible acts of sexual harassment in terms of taking her picture when she did not want it, comments, jokes that spread around the office. It was a very, very bad first day of work. And she comes to work on the second day and the same behavior continues. And so she quits at noon and files this sexual harassment case. And the question was, well, she was only here for a day and a half, so how bad was it? How bad could it have been? That doesn't reach the level of severe and pervasive. And in that case, the court said, look, this was terrible behavior. And even though it took place only over a day, the conduct was so offensive that we are going to find severe and pervasive behaviors. So, on your writing assignment, look to see how often the conduct occurs and how bad the conduct was. Now, when we talk about severity, of course, now your question is, how do we know? What is severity? Whose perspective are we going to use to determine severity? And this determination was historically based upon what was called the reasonable person standard. And this is a feature of tort law. Tort law involves things like negligence. When someone runs a red light and hits you in a car and or strikes you with their car, you're crossing the street. And what we ask is, was that person driving in a reasonable manner? Was that person doing what a reasonable person would do under those or same or similar circumstances? So the reasonable person standard was imported over into sexual harassment law. To answer that second component, remember that a reasonable person must have been detrimentally affected as well. So we're going to measure the severity not just by how this person reacted to it, but how would a reasonable person react to it. And the reasonable person standard was historically called the reasonable man standard. And what we've seen is that courts have increasingly changed their position from a reasonable person standard to what is sometimes called the reasonable victim standard, or the reasonable worker standard. Because what it does is it requires that you look at severity not from an anonymous grouping of random people, but look at severity from the perspective of this particular person at this particular time. Now, this reasonable worker standard has been adopted by the Supreme Court and is now pretty much the law of the land. And this came out of a case called Ellison v. Brady back in the early 1990s. And in this case, it involved a worker for the IRS, a young woman who worked for the IRS, and she was placed at the San Francisco office of the IRS, and there was another person hired at the same time, a man who developed a crush on this woman, and they never had any contact. They did not have anything other than normal workplace conduct. But in the man's perspective, they had a relationship. And so he would do things like write her a love note. He would, one time, they were going to have a lunch, just a work lunch, and everyone else dropped out of the lunch except for those two. And the guy sort of thought, well, that's a date. Whereas the woman thought, well, that's just a lunch. That's an unpleasant lunch. And eventually he gives her a note that says he's in turmoil. He can't understand why she's treating him so harshly. And again, they had really no contact at all. So the man is counseled as being, as for his behavior. You need to stop this. The woman complains about it. Eventually, the man is transferred to a different office, at which point he files a grievance saying that he didn't do anything wrong and he should be put back into his original office. The woman, Miss Ellison, realizes that he's being hired back, and so she becomes very upset and eventually files a claim for sexual harassment. Now, at the trial court level, they looked at it under the perspective of, this stuff happens, that sometimes you get a crush on a person, you may write love notes. There was never any threats. There was only threats of physical violence or anything like that. Instead, it was just expressions of admiration for the most part. But a verdict was rendered in favor of the employer, which is to say, well, this was not severe or pervasive enough to harm someone of a reasonable person would not have felt in any way threatened by this. But at the appellate court level, the court said, we understand that men and women may have different reactions to the same behavior. That women, for instance, are disproportionately the victims of sexual assault or physical violence. And therefore, a woman in that position may have a different reaction than what a man in that position would have had. If a man was faced with the occasional love note, he may think, well, that's nice, that's sweet. I don't have any interest, but that's sweet. Whereas a woman, there's always that threat of violence or assault hanging out there. And so the court reshaped the standard to say, let's look to see what would a reasonable person in that position say about severity. Look to what a reasonable person in that particular position, a young woman. Now, this standard was eventually adopted by the Supreme Court in a case called Oncali versus Sundown or Offshore Services. This case was important too because, first of all, it was the first same-sex sexual harassment, and it involved a young man who, 18 years old, had gotten his first job working as a roustabout on an oil platform which is 40 miles off the coast of Louisiana. And the way these work is it's an all-male environment, and you go out there and you spend a month or so, and then you come back and you are off for a month, and then you go back out to it. And Mr. Ankali went out for his very first assignment, and he goes to the oil platform, and immediately there's a lot of hazing going on. There's comments that suggest that he's gonna be raped, or don't drop the soap in the shower. Those types of comments. Now, the employer's perspective is, this happens to everybody. We're just joking around. He'll have to endure it for a month, and then there'll be someone else the next time, and he can join in the fun of making these sort of comments. But in the pretrial stage, when they deposed workers on the platform, and they asked, well, would you have done this to a woman in that position? Would you have done this to an 18-year-old woman? And everyone was like, oh, of course not. No, I would not have treated him that way. And what the Supreme Court has said is, okay, that's evidence of different terms and conditions based on sex. If you would not treat a woman that way, but you did treat a man in that way, then that is unlawful discrimination. So we need to look at it from the perspective of a young 18-year-old man off on his first job where he's on an oil platform located miles away from anything else. No way to get off of the platform. Remember, sexual harassment doesn't have to be about sexual activity. The harassment of the employee must be based on gender, but it need not involve sexual activity. So complaints or conduct that has a sex-related component, not sexual activity, but simply gender-related component, that is enough to rise to the level of sexual harassment. It's not just about sexual activity. For instance, if you had someone in the office who used derogatory terms, and those terms included some sex-related component, then that's likely to be sexual harassment, because again, people are being treated differently based on their sex. You should know that as employers, you should not dismiss a sexual harassment claim simply because it doesn't involve sexual activity. That's the classic claim that we see on the web or we hear about in the news, the sexual activity, but that's not all that sexual harassment is composed of.